If you cannot afford an attorney, one will be provided for you. It is the most famous phrase in American law, repeated in almost every police procedural on television. But that guarantee comes with a massive asterisk. It only applies in very specific courtrooms. If you are sued in a civil lawsuit, even if you did absolutely nothing wrong, the Constitution does not guarantee you legal representation. The right to a free public defender vanishes. You are left with two choices: pay out of pocket to hire a private lawyer, or try to navigate thousands of pages of complex legal codes completely by yourself. This happens because the United States justice system is split into two distinctly different tracks. Criminal law deals with offenses against society as a whole. Civil law is designed to resolve private disputes between individuals, businesses, or organizations. Because these two tracks have entirely different objectives, the constitutional rules change depending on which door you walk through. The specific protections available to you depend entirely on how the government classifies the legal threat you are facing. In a criminal prosecution, the stakes are absolute. The government is seeking to take away your physical liberty through incarceration, or in some cases, your life. Because the state holds the power to lock you in a cage, the Sixth Amendment grants you heavy defensive shields. If you are facing jail time, you have the absolute right to a trial by jury and the right to a government-funded attorney. This specific protection was cemented after Clarence Earl Gideon, a man accused of a felony, petitioned the Supreme Court from his prison cell and won. Criminal courts also demand the highest standard of proof in the legal system. To secure a conviction, the prosecution must prove you are guilty beyond a reasonable doubt. In a criminal case, the burden of proof scale weighs heavily for the defendant. Switch to a civil courtroom and the rules loosen. The burden drops to a preponderance of evidence. A jury only needs to be 51% sure you're liable. There is no better example of this disparity than the trials of O.J. Simpson. In 1995, Simpson was acquitted in criminal court because the state could not meet the strict burden of proving his guilt beyond a reasonable doubt. 2 years later, he was sued for the exact same act in civil court. Because the threshold was only 51%, the jury found him liable for $33.5 million. The exact same action can be legally unprovable as a crime, yet cost you millions in a civil dispute, simply because the rules of evidence shift entirely based on the venue. So what happens when government officials abuse their authority, but prosecutors refuse to press criminal charges against them? This is where civil law becomes an offensive weapon for citizens, utilizing a federal statute known as Section 1983. A Section 1983 lawsuit allows you to directly sue government employees, like police officers or prison guards, for financial damages if they violate your constitutional rights while acting under the color of law. However, the government relies on a massive defensive roadblock to stop these civil lawsuits, a doctrine called qualified immunity. This shields officials from personal liability unless a court decides they violated a clearly established constitutional right, which is notoriously difficult to prove. That legal landscape is beginning to crack. States are passing their own civil rights laws, like California's Maine Act, which actively strips police officers and guards of their qualified immunity defenses in specific injury cases. Civil litigation provides a pathway for citizens to force financial accountability onto the state when criminal prosecutors choose not to act. Whether civil or criminal, almost all federal cases start here, at the trial level. Across the country, there are 94 federal district courts, where witnesses testify, juries sit, and the facts of a case are officially established. If you lose a trial and believe the judge applied the rules incorrectly, you can appeal your case up to the Circuit Courts of Appeals. Here, panels of judges don't look at the facts again. They only review whether the law was applied fairly. The hierarchy ends at the United States Supreme Court, the final authority on constitutional interpretation. But getting a case heard here is incredibly rare, agreeing to issue writs of certiorari for less than 1% of petitions received every year. Despite this elaborate hierarchy and the heavy constitutional shields provided at trial, the overwhelming majority of people never see the inside of a courtroom. 97% of all criminal cases end in plea bargains, completely bypassing a jury. The specific rights you can invoke change significantly based on whether you are defending your physical freedom or your financial assets. Navigating the American legal system requires recognizing which rules are in play before the trial begins. The protections you have on paper are only as strong as your knowledge of the courtroom you're standing in.